Recording has started.
Chair Schmidt, do you want to introduce the meeting or shall I?
Please. Yeah.
Okay. This is the Sunshine Ordinance Task Force Complaint Committee of the City and County of San Francisco. We are meeting in hearing room 408 at City Hall, 1 Dr. Carlton B. Goodlett Place, San Francisco, California. This is a regular meeting. Today's date is July 18, 2023, and the time is 5:35. Remote access or in-person participation. The Sunshine Ordinance Task Force and its committees convene hybrid meetings that allow in-person attendance, in-person public comment, remote access for petitioners and respondents, and remote public comment via teleconference. The WebEx remote link login. tinyurl.com/22er35k9. The password is sunshine. The telephone call-in number is 415-655-0001, and the meeting ID is 2598-795-5499 ##. Press 3 to enter the speaker line. Shall we begin with, do you want to state meeting decorum, Chair Schmidt?
I don't have it up on my screen.
All right. Yes, meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. Shall we call item number 1?
One, please.
Item number 1, call to order, roll call, and agenda changes. Roll call. Member Wolf.
Present.
Member Wolf present. Member Stein. Member Stein present. Chair Schmidt. Chair Schmidt present. We have a quorum. Shall we address agenda changes?
Yes. Agenda changes.
I can't hear you.
Are there any
Oh,
agenda changes? How about now?
Yeah, perfect.
Okay.
Okay. I have one agenda change that I was made aware of last Friday afternoon. Item number 4, file number 23006, complaint filed by Amy Silverstein against the Office of the Treasurer and Tax Collector for allegedly violating Administrative Code Section 67.1A as an apple by failing to serve the public and reach its decisions in full view of the public. D, by failing to let the public know what their government and those acting on behalf of their government are doing. 6724B1I through 2I, by failing to provide information on litigation materials, and 6736, by failing to allow the Sunshine Ordinance to supersede all other local laws. That case was removed, like I said, late last Friday afternoon.
Mr. Chair.
Yes.
Yeah, I would like to make a request when those happen that the committee members or whatever committee or the task force be notified immediately. I spent a lot of my weekend reading that file, which is extremely long and large and complex.
That's fair. Yes, I can.
Yeah, I think especially that kind of case, I think that, what was it, about 700 pages of a file. So, yeah, I think that any time an upcoming case is taken off the calendar and it's a matter of, people are preparing for the hearing, if we could just get notice out to the panel members as soon as possible, that would be great.
Yeah, and this is Member Stein. I would just add that if you could make it a high priority email, like an urgent email, and maybe even have something in all caps, that would be very helpful.
Any other agenda changes?
I have another.
Okay. Yes, Member Wolf.
Yeah, so for items like item number 7 and 8, okay, where they are fairly common. I mean, we can't necessarily combine them, but the matter of whether, it's within our jurisdiction, whether it's a public record or not, is, might be considered to be fairly straightforward. If we can maybe have them all in one meeting to kind of get them out of the way, because I imagine that all of these were filed pretty close together.
You're talking about the Petrellis cases? Yeah, we should bunch them and try to figure out a protocol to just get them done real quickly, since the same issues are in each one.
That's fine, but right now we don't have anything other than Mr. Petrellis's case that are related to a property calendar.
There were, I understand that, but in the previous meeting last month, he also had others for other supervisors for the same exact complaint. So I'm suggesting that they all, if they're all being, if they come in all in 1 month, then we take care of them all in that month's meeting.
But how do we address then?
May I ask a question? This is Victor Young.
Yes.
There is the general rule that we don't have more than 2 complaints per complainant on a single agenda. So that would have to be factored in.
I understand that, but this is kind of like a quasi, we can't combine them with, because they're different respondents. But the issue is, it's the same for all the complaints. I'm just looking at a more efficient, kind of build a little more efficiency and provide a little more room for future, other agendas, so we can get some more complaints faster. Just a suggestion.
Sure. It does seem that there is somewhat of a contradiction there, because the rule, it says 2 max. Maybe that could be somehow amended to deal with this kind of situation. We should definitely consider that as a possibility.
Yeah, it may be something to have the rules committee take a gander at.
Sure. Yeah.
Thank you.
Sure. I'm going to have one quick question, but let's see if there are any more agenda changes. I don't think there are. But my question is, if anyone knows the status of whether there's been any change to people appearing here remotely, is it everybody who's a party allowed to appear remotely? Is it just petitioners? Is there any change?
Chair Schmidt, this is Victor Young.
Yes.
As far as I know, we have not changed any rules. Members are required to show up in person unless they have a waiver. All of the parties are allowed to participate remotely at this time.
Okay, so petitioners and respondents and witnesses are allowed to participate remotely. Thank you, Victor. Okay. That's what, anything else on number 1? Okay, let's
I do have a few hands raised. I don't know if they wanted to comment on this, but
well, let's allow comment, see if someone has something to say about it. I don't have a problem with that.
okay. If you would like to make public comment on this matter, you can raise your hand by pressing *3 if you're on the telephone, or otherwise use the application. I'm going to go ahead and unmute our first person with their hand raised.
Could we get your name if you're making public comment?
Hi, This is Michael Petrellis calling in. I first wanted to verify that I had successfully dialed in and raised my hand. Regarding the matter at hand, I want to thank you, commissioners, for proposing consolidating the complaints that I have filed recently regarding calendars with supervisors in particular. If there is a way for you to legally streamline such requests, which unquestionably are about public records, I'm talking about the Prop G calendars, a streamlining process would be appreciated. Thank you.
Thank you.
Thank you very much. Moving on to our next caller. Caller, I have unmuted you if you'd like to make public comment on item 1.
And please start with your name. Maybe there's no public comment from this person. All right.
Moving on to our next one.
Great. Can you hear me now?
Yes.
Yes, I can.
It's David Pilpel. So I was actually somewhat intrigued by item 4. Couple of points there. If there is a change to the agenda, if it's possible to post an amended agenda and, just indicate that this item will not be heard and what its status is, that would have helped not just members of the task force, but members of the public, because I would have, made other plans for tonight. Can you also just clarify as to item 4 what its status is and the reason for not hearing it? Is it still an active file that for which a continuance was requested and granted, or has the matter been settled, or what's just its status? That's all. I'm not getting into the merits right now. Thanks.
When I heard from this particular petitioner, she just said, I would like to close out my complaint. That's it.
This is Victor Young again. If we can get that confirmation in writing that she is withdrawing, it would be appreciated. Otherwise, we may have to close it due to inactivity.
Too bad. It looks like they spent a lot of attorney's fees getting it before us, and also too bad because it was a complicated one, and also I thought there were some issues there that were quite intricate in terms of the law. All right. Any other public comment, Victor?
Sorry, my apologies, Chair Smith. At this time, since we don't have anything in writing, maybe we can just continue it with the intent to close it out, or something to that effect once we get to item 4. Because a verbal statement of not wanting to proceed is not good enough for us. Something in writing.
I completely agree. Let's do that when we get to that number. We'll be clear about it when we get to the number.
Okay, have we
Any more public comment? Otherwise, we'll move to number 2.
I have no more indications of public comment for item 1.
Number 2.
Oh, 1 second. Someone just raised their hand.
Okay, we have one more public comment.
Hello, caller. I have unmuted you. I will defer to Cheryl for your public comment.
I believe you just spoke on is number 4, the Amy Silverstein matter.
Yes.
Well, she did send something in writing. It wasn't verbal.
Okay.
It was sent on Friday, July 14th, 2023 at 9:12 a.m.
And could you tell us what the content is of that written item?
It's to the SOTF, BOS, and me. Good morning. We have decided to withdraw our complaint file number 23006. Thank you to the Sunshine Ordinance Task Force and its staff for their service in this matter.
Okay.
Amy Silverstein, her letterhead, etc.
Withdrawn. All right. So we'll call it when we get to number 4, but we'll just clarify what's happened here. Thank you for giving us the actual language about what had happened.
Yes, and it is in writing, so it should be in your email.
Okay. Thank you.
Thank you.
Okay. Number 2.
Item number 2, approval of the June 2023 Complaint Committee meeting minutes. I have a copy of the minutes. Does anybody have any comments?
Okay, let's start with members. I have no edits myself. Members, anything?
This is Member Stein. I have a few edits. So on P2, it says Chair Schmidt called the meeting to order. I believe Chair Schmidt was not there. So I think it should say Chair Wolf called the meeting to order. And then P5.
Wait a second. Yeah, okay, well. And
P5 under item 6. It says ayes 3, Stein and Wolf. It should say ayes 2. Page 6, item 7. It should just say under action, it should say moved to table and dismiss the matter, not dismissed, past tense. And then page 7, item 8. Wait, no, sorry, it's page. I think it's page 6, item 8. It should just say somewhere it says computer added dispatch. It should say computer aided dispatch.
that's in item 8.
It's in item 8. It's the second paragraph, the third line down. It says computer added dispatch. Second paragraph, item 8.
Yeah, I'm looking for it right now.
Third line.
Computer provided 3 individual computer dispatch numbers. Let's see.
No. Jorge Rivero provided a summary of the complaint and requested the committee to find a violation. Mr. Rivero said he requested a copy of a computer aided dispatch, not added dispatch.
Okay.
And you might want to use the acronym CAD because that's what everybody uses.
If you use it, I would put it in parentheses after computer aided dispatch.
Correct. Thank you.
And those are all my changes.
Member Wolf, do you have any comments?
No, I picked up the same ones.
All right, thank you very much.
Yeah, I have no opposition to making any of those changes. Okay, I'll move to approve as amended.
Second.
Public comment.
Yes, if anyone would like to make public comment on this item, you can raise your hand. If you're on the phone, it's star 3. If you're on the application, you can use the application to raise your hand. I will unmute our next caller.
David Pilpel, just very quickly, the comment on item 7, the action taken to table and dismiss the matter, that's true, and I think that same language applies to item 4 on page 3, to table and dismiss, no ED, the matter without prejudice, blah, blah, blah. Other than that, that looks good to me. Thanks.
Joe, did you catch that? Okay, what Mr. Pilpel said. Yeah, we'll make those changes too.
You gotta speak up, Dean.
Okay. All right. Any other public comment?
I do not have anybody else listed for public comment.
Okay, thank you. So I think we're ready to vote to approve.
Who was,
One moment. I just had someone raise their hand and lower their hand. Never
Yes.
mind.
that?
Taking public comment from the room,
Stop.
the question. You skipped it last time. I didn't hear call for public comment in the room. So I'm asking if you're doing it on this item.
We certainly are welcoming public comment from the room. It's not a separate item. And if anyone hears the call for public comment, please step forward. and
Okay,
hear from-
I didn't hear the second on the motion.
Member
Oh,
Wolf.
it was Member Wolf
Okay.
was the second. And we have a public commenter present in the room who can go next when Cheryl's ready.
Okay, do we have a public commenter online, Victor?
You're taking it from the room for the previous item.
Yes, for the motion. We have one public commenter present here.
Okay. Mr. Warfield, did you want to make public comment?
Yes, thank you. I'm used to there being clarity about who is being requested for public comment. When I hear Victor being asked about public commenters electronically, I don't sense that the room has been called upon. Also, in terms of sequence, you can choose the sequence, I suppose, but I think it needs to be clear. Also, I don't see anything where I can see, for example, Member Wolf. I think he may be, I can't see who that thing is on the right. It's a person, I guess it's Member Wolf, but it's on the administrators. I think I see a hand waving. It's on the administrators. In the past, I think there have been remote participants visible on the large screen in the room. So I'm wondering has the protocol changed? It's even from the podium, I really can't tell what's going on. It's very small. That's a question. With respect to the changes that were proposed by Member Stein, I do appreciate care with the minutes. I very much appreciate that. However, I had trouble following what the changes were when page numbers and item numbers were referenced, because I couldn't find from the page number the item number, except on the last one where I believe the comment was about file 23023, item 8 on page 5. But the other ones I had a great deal of trouble following, and if you might, I would very much appreciate if you could just quickly go over what the changes were that were proposed. And otherwise, I wasn't at the meeting and I don't have a comment. It's just that trying to follow the changes, I think it wasn't clear to me as sitting in the room.
Should I do that?
If-
Okay.
Member Stein, if you would.
Okay, so,
I should let
oh, yeah, go
him
ahead.
finish his
Oh, okay.
comment, and then as Member Stein wishes to respond when you're finished.
Thank you very much.
Okay, thank you. Member Stein.
To go over those changes again quickly, I hope. P2, which is I'm referring to the numbers at the bottom of the page of each packet. Under item 1, that's, the number 1 on, it's the second page of materials in the packet. In the packet, what are those numbers called at the bottom of the page, Cheryl?
I don't,
You could call them
Follow.
Bates numbers.
Are they the Bates numbers?
they are Bates numbers.
Okay, so they in the thing that the public gets? Yes, we are talking about the minutes. There's no page number at the bottom?
base numbers on these pages don't have a P in front of them.
Oh, okay. So,
That's what's confusing.
but is there a 2 at the bottom of the page?
There's not a 2 from when I scanned.
Okay, then I'll just say under item 1, the first item, those numbers don't change. It says that Chair Schmidt called the meeting to order. I corrected that Chair Wolf called the meeting to order. Chair Schmidt was not at the meeting. That's under item 1. Under item 6, it says that there were 2 ayes. I mean, it says that there were 3 ayes, and it should say that there were 2 ayes because there were only 2 committee members present. Under item 7, I just said that it should say dismiss, not dismissed, that the complaint was that we would dismiss it under certain, we intended to dismiss it, but not that it was already dismissed. And then I believe Mr. Pilpel added that also appeared in a later item, that the wrong tense was used. And then under item 8, there's a reference to the phrase computer added dispatch in, I believe it's the second paragraph, the 3rd line down, and it should just say computer aided dispatch.
Okay, much appreciated, Member Stein. I think it's all made clear at this point. Okay, having concluded public comment, let's go ahead and vote on this.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Stein?
Aye.
Member Stein, aye. We have 3 in favor.
So next we will have number 3, general public comment. When you're ready, Victor.
Now, item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Yes, if there's anybody who would like to make public comment, if you're in the room, you can approach the podium. If you're online, you can raise your hand by pressing *3, or otherwise use the application to raise your hand.
Do we have anyone online?
No one has raised their hand yet.
Okay, so let's go to the room then. We do have a commenter when Cheryl's ready.
Yes, please.
Just a moment, Mr. Warfield.
Beg your pardon?
We need to reset the timer.
You ready, sir?
Yes.
Go ahead.
Thank you. The sound quality here is kind of booming. It's a little hard to understand, and sometimes the volume is rather low, just so you know. I have some procedural questions or concerns. At the Sunshine Ordinance full task force meetings, there are detailed procedures shown that are fairly straightforward about how you proceed with hearings about complaints. Essentially, 5 minutes for the complainant, 5 minutes for the respondent. Then there can be discussion, I believe, but in any case, there's 3 minutes for each, the respondent and the rebuttal. The respondent and the complainant each have 3 minutes for rebuttal. I looked in vain for procedures on the hearings in this hearing room, number 408, and I couldn't find anything. I did get in touch with the administrator, who said that it's, bottom line, said that it's up to the chair. And I asked, is that written any place, either in the agenda or any place else, for example, in procedures? And I was told no. So I was told it's basically up to the chair. And that I said to the administrator, it seems that whatever the rules are, they should be clear with respect to how hearings are conducted. There's a lot of material very often, and even the simplest complaint seems to me there should be clarity about procedure. People need to know what to prepare for. As I understood it from the administrator, it would be up to the chair on each of the complaints. I certainly would hope that the hearing procedure that's outlined in the procedures for hearings in your bylaws, I believe, or wherever you have them, would be followed, because I think it's a reasonable approach that the presenter presents the complaint first, the respondent can respond, and then in particular, the sequence of rebuttals. The rebuttals, I think, fairly and properly are such that the respondent gets to make a rebuttal first, and the second person to make a rebuttal is the complainant. And I have no idea what to expect for this hearing, or for that matter, wherever you don't have anything listed on the agenda. So I also would like to ask if the chair can explain what the procedure will be today. Thank you.
Thank you. Unless there's other public comment, we can move on to number 4.
There's no, oh, we have one person just raised their hand.
All right. When Cheryl's ready.
No, I'm ready. Do we have another speaker?
Yes, David Pilpel, very briefly.
Go ahead.
As long as everyone's sitting down, I will agree with Mr. Warfield tonight on this particular point. I think the boilerplate that's on the full task force agendas at the end about meeting procedures should be used for both the full task force and the various committees. So the procedures that apply to hearings apply throughout, and just that, you know, the appropriate boilerplate be used, and to the extent that it wasn't or hasn't, that that be attended to in the future. I don't see a huge problem with that. Those are my thoughts. Thanks for listening.
Okay, thank you. I think number 4 is next.
Item number 4, file number 23006, complaint filed by Amy Silverstein against the Office of the Treasurer and Tax Collector for allegedly violating Administrative Code Section 67.1A by failing to serve the public and reach its decisions in full view of the public. Item D, by failing to let the public know what their government and those acting on behalf of their government are doing. 6724B1I, by failing to provide information on litigation materials, and 67.36, by failing to allow the Sunshine Ordinance to supersede other local laws.
And it's go ahead.
Since this matter was withdrawn, I would state that this matter is no longer under the jurisdiction of the committee, and we don't need to take any action on it.
Yeah, the matter was withdrawn, and it is. We now know it is confirmed in writing that it was withdrawn by the petitioner. I think that's all we need to do. Thank you, Victor. Okay.
We do have a public commenter if you'd like to accept that.
Well, I'll allow it. I'm not sure if. Yeah. Okay. Public comment. Go ahead, Victor. When Cheryl's ready.
Do we have a speaker ready?
Can you hear me now?
Just a point of order, Mr. Chair. Do we have an action on the floor with a maker and a second?
No, there's not. I guess I'm giving some leeway here.
Okay.
Go ahead, Mr. Pilpel.
Yeah, David Pilpel again. I think this is it for me for tonight. I understand now that the matter was withdrawn and is not before the committee, so no action needs to be taken. I went back and found that the EOT committee discussed a related complaint in March. And I just wanted to confirm if it's possible that that file 23004 against the city attorney's office, that is still live, and it's only 23006 that was before the committee tonight that's been withdrawn. And so there are some related issues, and I'm hoping that they get discussed at some point, because this really is a bit of fascinating stuff, and I hope it's not all completely lost to the wind here.
Okay, thank you. Does anyone know if there's some status update on that other number 4?
Give
I
me a
don't.
moment. I will look it up. According to what I see, it was heard by EOT and it's pending a SOTF hearing.
Great. Okay. Thank you very much. Enjoy the rest of your evening.
Okay, thank you. It looks like we may have a public commenter in the room.
Mr. Young, do we have a public commenter online?
You can take the room.
Mr. Warfield, did you want to make public comment?
Yes, please.
Okay. You may begin.
Thank you for answering the question that a member of the public, Pilpel, asked on item 1, and what seemed to be the subsequent explanation about the reason for the withdrawal, including who requested it and how, and a discussion a little bit by Victor as to whether or not there was confirmation. I did not understand in the room who spoke to confirm that this item was withdrawn and when and how. I didn't follow that from the sound that's available in the room. And so I think since it's this particular item, it might be helpful to just fill in those bits that were mentioned in item 1, because it's related on this item for those who might want to listen to this item and understand better what happened. Thanks very much.
All right, thank you.
I do not see any additional hands raised for remote comment.
Okay, and I'll just say it. I believe it was Ms. Liu, who's here on another matter, who clarified that there was a withdrawal, and that's Ms. Liu from the Treasury and Tax Collector's Office. Okay, I will. Before we go to the next item, this is the point in time where I will explain what procedures we're going to follow here. We do not, in this committee, follow the same procedures as before the full task force. There's no clear rule in writing, as far as I can tell, as to what procedures should be here. Here we have no ability to make any final decisions. This is a committee that basically looks at a couple of preliminary questions. Are there public records or public meetings involved? Does the task force have jurisdiction? We may make recommendations. Sometimes we do, sometimes we do not. And in many cases, we will send the matter to be heard before the full task force, but only the full task force can make any decisions. That's how the rules are written at this time. We will hear first for up to 3 minutes from the petitioner, and then for up to 3 minutes from the respondent. Then the matter is open for questioning by the members to either party. There are no rebuttals. After questioning, we will make a determination as to what to do with the matter. All right, let's call the next item, please.
Item number 5, file number 23052, complaint filed by Stilian Bajanski against Deborah Liu and the Office of the Treasurer and Tax Collector for allegedly violating Administrative Code Section 6721 and California Government Code Section 6253C as in cat by failing to respond to a records request in a timely and or complete manner. This is the first time this case has been heard.
This is Victor. If the representative from the Office of the Treasurer and Tax Collector can raise their hand so I can identify you. Thank you very much. And then I believe that Ms. Bajanski is present. I have made them a panelist. Oh, give me a second. Okay. We should have all members present.
Excuse me, Dean, you said 3 minutes each party?
Oh, yeah.
Okay. So shall we begin with the petitioner, Mr. Young?
They are unmuted at your discretion.
Is this the petitioner that is Mr. Bajanski?
Hello, can you hear me?
Mr. Bajanski?
Yes.
Okay, great.
Can you
Just
hear
I just wanted to be clear about that. Okay. You have
All right, great.
3 minutes to make your presentation. Are you ready to begin?
Yes, I'm ready.
Go ahead, sir.
Hello, my name is Stilly, and I would like to mention 2 things. First, I'm not sure whether Mr. Tyrrell of Treasury and Tax is aware of this complaint, but this is my 8th complaint in the last 4 years towards the Tax and Treasury team for pretty much the same reasons. Some of the excuses that I've heard so far for not delivering the public request on time are not good enough software that can process the privacy reduction, not enough people in the department to handle the request. The petitioner submits too many requests. The petitioner requests contain a lot of information which takes longer to process, and the petitioner requests information which is already public. Due to the COVID emergency mayor's proclamation, the respondent claimed that they have unlimited time to respond to any request. The most popular excuse of all was that there is pending litigation, which took most of the time since there was plenty information withheld due to attorney privilege. Out of the 8 complaints that I brought up to the Sunshine Task Force, violations were found in 3 of them. Regarding complaint 23052, I submitted the public request 23-1965 back on April 11, 2023, and it was not closed until May 19, 2023, which is 38 days. Just as a comparison, the local Sunshine Ordinance task ordinance sets the time to respond to a public request to 10 days, and California Government Code 6253C sets it to 24 days. As you can see, there is quite a delay in terms of delivering the public request. Also, it's important to note that during this time, there was no pending litigation. There was a judgment entered based on the pending litigation on March 8, 2023. So I'm curious what kind of excuse the Tax and Treasury team has now. Second, I'm well aware that the Sunshine Task Force Ordinance doesn't not have any executive power, but I will keep raising those complaints because there is a lot of advertising that the local ordinances are better than the state laws. Maybe they are, but so far I haven't seen anything better, especially when it comes to the timing of releasing public records. Thank you so much. That's all from me.
Thank you. When Cheryl's ready, we can hear from the respondent now.
May I ask who's speaking for the Treasurer and Tax Collector's Office?
Yes, this is Christopher Terrell. I'm the Assistant Tax Collector Attorney at the Treasurer and Tax Collector's Office.
Is your name spelled Terrell?
It's Tirrell.
Thank you so much for that. Are you ready to begin speaking?
I am.
Go ahead, sir.
Good evening, Honorable Task Force members. This request arises as a result of Mr. Bajanski's 24th Public Record Act request to the Treasurer and Tax Collector's Office in the past 23 months. The requested issue here was submitted on April 11th, 2023 at 9:12 a.m. Within 15 minutes of receiving petitioner's request, the legal staff assigned the IT section to pull the responsive records. IT staff provided email records for 26 TTX staff members. Ultimately, there were found to be 240 responsive items. Many of these items were subject to privilege and redaction, required a large amount of time from TTX staff to sort, review, and redact the documents. The legal assistants spent approximately 8.675 hours per week for a total of 46.75 hours, ultimately producing 240 responsive items, I believe. The response was replied to in a timely fashion. TTX receives many responses, many requests from other requesters. Mr. Bajanski is not treated any differently than any other requester. We work to respond to and provide responsive records as quickly as possible.
Yeah, thank you. All right, so at this point, we may have questions from the members to the parties. Member Wolf, anything?
The only question I would have for the respondent, have you claimed that any documents were not disclosable? And have you withheld any documents?
Yes, there were documents that were withheld on the basis of attorney-client privilege, attorney work product doctrine, and taxpayer confidentiality.
Were there any documents that you claim to be not public? And did you cite those, any statute with related to that?
Yes, in each case where a document was redacted, a redaction reason was given and a citation to the code section that was applicable was provided. In addition, any documents that were withheld in their entirety were also identified for the reason that they were withheld.
Okay, thank you. I asked those questions only to assure that we have a complete record for the task force if this item gets approved. Thank you.
Thank you.
Yeah, I don't know if there's any other questions that we have at this time. So we certainly could talk about what we want to do with the matter. I don't know if I'm seeing any questions about jurisdiction. These are clearly public documents that are involved here. Members, any thoughts on what to do with this?
This is Member Stein. So my understanding is this was an IDR, that the department did respond within 1 day saying that it was going to take longer to supply the materials. They, in keeping with the rules for IDR, they released documents as they were available. So their first release was 10 days later, and their final release was about 5 weeks later. It seems like there are some kind of legal cases going on between the petitioner and the respondent. So it seems like, it's legitimate that it had to be reviewed for confidential legal information or attorney-client privilege. So my inclination would be to say that these are public records under our jurisdiction. but to forward it to the consent calendar with a recommendation of no violation.
I'll second that. Public comment.
Yes, if there's anybody in the room who'd like to make public comment, you can approach the podium. If there is anybody online who'd like to make public comment, you can raise your hand by pressing *3 or otherwise using the application to raise your hand. Okay, I'm not getting any indications of public comment for this matter.
Thank you, Victor. We can have our vote then.
Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Wolf?
No.
Member Wolf, no. 2 in favor, 1 against.
Chair Schmidt, I just want to bring up a possible issue. If this goes forward on the consent agenda, I'm not sure if a unanimous vote is necessary on the consent.
I thought the motion was for no violation.
It was to refer to the consent agenda with the recommendation for no violation.
Oh, okay.
I would, I mean, I think your question, Victor, is a good question. My inclination would be to think that a 2-to-1 vote would serve the same as a unanimous vote. I don't know if there's any provision that says that unanimity is necessary in any situation. I certainly am open to being corrected on that, but my inclination is to think that this 2-to-1 vote would suffice, just as a 3-0 vote would suffice. Does any members, do you know of anything that differs from that?
I don't recall, but maybe Member Wolf does.
Well, I mean, unanimous is very different than majority. They're not interchangeable.
No, but the question is, did we have rules? Did we set up any rule saying that things could only go to the consent calendar if there was unanimity?
Oh.
That's the question.
I am not.
Or is it just, are we just relying on a quorum, a majority?
I don't think there was a.
I don't recall it either.
I don't recall it either. Hold on.
This is Victor Young. I don't believe that the Sunshine Ordinance Task Force addressed that issue. I was just going based on general knowledge that if it's on consent, there's usually no opposition.
But the way we understand consent, things can still be pulled off the consent calendar if there is disagreement.
Yeah.
So if people read it and say, no, this needs to have a full hearing at this full task force level, it can still be pulled off the consent calendar. So that to me would also mitigate against needing to have unanimity. It's not a done deal just because it's on the consent calendar.
Correct. But the procedure here is still, there's still validity based upon the procedure here. If the determination for a tally of a vote is supposed to be, unanimous versus majority, that makes a difference. Because it would mean it was supposed to be if it's supposed to be unanimous and it's not, then it would fail.
Right. But I thought if there's quorum and there's a majority, that's what we accept. Yeah.
That's my my recollection.
Mhm.
Yes, based on your responses, I believe we can move forward with the vote. The issue of that issue was not brought up previously.
Yeah, if someone finds the word unanimity in the rules that were set up for the consent calendar, then that would make a difference. It would make a big difference. But I don't think anyone thinks that there's any such word in there or any word that's has the same significance as unanimous. So I do believe that the vote that we just had does send this validly to the consent calendar. And at full task force, any member can pull it out so that is an option that has not gone away here. Okay, so I believe that matter is concluded. We can move on to the next item.
Thank you, task force members.
Thank you.
Item number 6, file number 23034, complaint filed by the Library Users Association against the San Francisco Public Library for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. This is the first time this action has been heard.
Okay. First, when Cheryl's ready, 3 minutes from the petitioner, followed by 3 minutes from the respondent.
This is Victor Young. I was wondering if the petitioner can raise their hand if they're online so I can identify you. Okay, thank you very much.
There's nobody at the podium in the room on behalf of the Library Users Association yet. Oh, well, now we do have a petitioner.
Do we not have a respondent? Because I heard
We do have a respondent. I see your hand raised. If you can identify yourself, it would be appreciated.
Yes, hi, thank you so much. This is Margot Shaw with the library.
Yeah. Okay.
Great, thank you. Okay, let's begin with the petitioner.
Mr. Warfield, you ready to begin speaking?
Yeah. This is Peter Warfield, Executive Director, Library Users Association. Our complaint is pretty straightforward, and it's on page 778. This is a complaint and request for hearing regarding the following. 1, the city librarian's refusal to talk or allow access to anyone, including himself, in his suite of offices at the main library after we knocked on the closed door during regular business hours on March 10th, 2023. Instead, he said, I would have to, quote, come back Monday, which was March 13th. And second, the city librarian's representative, which is Margot Schaub, refusal to allow inspection of requested materials during regular business hours in her office or the city librarian's office on a separate day, namely the following Monday, March 13th. She said she would allow no future inspection of the material previously provided by email at the city librarian's offices without an appointment. The law is quite clear. Section 67.21A, and let me say that I believe that the agenda is stating it incorrectly. I tried to get a correction from Chair Schmidt and from the administrator, and the way that the agenda reads is not what the complaint is, although it certainly is about 6721. So the first section, 6721A, that we cite, all of this has been on page 778. Every person having custody of any public record of public information, and so on and so forth, shall at normal times and during normal and reasonable hours of operation, without unreasonable delay, and without requiring an appointment, permit the public record or any segregable portion of the record to be inspected and examined by any person. And section 67.21L, as in Larry, inspection and copying of documentary public information stored in electronic form shall be made available to the person requesting the information in any form requested, which is available or easily generated by the department, its officers or employees, including disk, tape, printout, or monitor at a charge no greater than the cost of the media in which it's duplicated. The library, unfortunately, has a lengthy answer. We gave a lengthier response to their answer, which you can find on page 785. And their response, which we've marked, starts on page 799. But I'd like to draw your attention with 7 seconds remaining. The library merely this is from their answer, merely requires some reasonable advance notice from Mr. Warfield when he seeks an opportunity to inspect records that have already been provided via email.
Mr. Warfield.
Thank you.
Thank you.
We can now hear from the respondent.
Hi, this is Margot.
Again, let me just confirm that the members have already read the written documents in the record, so we know that we know the substance of the case. But go ahead, Ms. Shuck.
Sure. I was just going to refer back to the letter and our response that we promptly and fully complied with Mr. Warfield's public records request. He does not dispute that all records he sought from the library were provided to him. His allegations are inaccurate and fail to state any claim for violation of the Sunshine Ordinance. When he knocked on the door to the office, the city librarian's office closes at 5 o'clock. When he references Mr. City Librarian Lambert requesting that he come back on the 13th, I think he said, it's because the office was closed. And so the office closes at 5 o'clock every day, and it was after hours. In response, I did not say that Mr. Warfield, when we had our interaction in my office, that he had to make an appointment. What I said was, I can't give you the documents right now because I don't have them. If you'd like to come back in 15 minutes, I can print them. I had already delivered him the public records request that he asked for by email and through the Next Request portal. So he had them, and I just needed time to print them out. So I asked him to come back in 15 minutes. He refused and said he didn't have 15 minutes. So I said, well, you can make an appointment and come back and pick them up whenever you would like. Thank you.
Thank you. Okay, at this time, members, do you have any questions for the parties?
This is Member Stein. I have a few questions for the petitioner and respondent. So, Mr. Warfield, what time do you recall going into the office originally? Was it before or after 5 p.m. in your recollection?
Peter Warfield here. As I've described on page 768, in the first full paragraph, the answer is it was before 5 o'clock, very definitely, because for the reasons I've mentioned in the next 2 paragraphs, if I may read them, I think it would be clear.
Well, I do remember you saying it there, but I just wanted to see if you still were maintaining that. Did you say it was like 4:45?
I came at approximately 20 to 5 to the office for the first time and knocked on the closed door, and I'm not sure if she's still the chief financial officer, answered, and I said, do you have something for me? Because I wanted to see the paper actual documents. That was a particular thing that the library had already on March 8th told me they had provided. So she came back with a brown envelope, and I said, thank you, went to a different part of the library, looked at it, and came back before 5 to ask, to look for the material about the requested material. I certainly requested agenda. She gave me an agenda for the next week's commission meeting, but not the material that I had requested and that the library claims was delivered by email. And then I subsequently went to the public relations office on another errand, and they were open. They always close sharply at 5. And I chatted with them. They have a clock. It was about 5 minutes till 5. And yes, it was a Friday afternoon, but this was business hours and they were open and all the folks were there, and we chatted for a while until they closed at 5 o'clock sharp.
Okay, and then you also say in the packet that you were just expecting a copy of the documents, that you were not asking to see personal workstations. Is that correct?
That's right. And I have to say that I don't know what is meant by personal. This sounds a little like when the library unlawfully denied us the so-called personal emails of the commissioners in a previous complaint that the Sunshine Task Force found in our favor. Those, as far as I know, those monitors, computers, offices are all publicly paid for. And even if they were quote unquote personal, whatever that means, if they're doing public information on those, then as I understand it, that material can be looked at. And that's what we quote in section 67, that the law specifically says electronic information can be inspected via printout or monitor.
And then another question was, when you came back on Monday, do you recall being asked if you could wait 15 minutes to get
Yes,
material?
I do.
And
we had, let me say, before the 15 minutes was brought up, I had a whole lot of obstruction and resistance, as I mentioned on 778 in the original complaint. The same representative repeatedly and adamantly demanded to know why we were not satisfied with the previously emailed response, why we couldn't go and look on some computer at the library ourselves, on and on. She had plenty of time for that and expressing a kind of indignation, but there was no offer of a provision for in-person inspection. I had to finally do something I'm very reluctant to do in my dealings with anybody, and that is to specifically say the law requires such and such. And at that point, and only then, did Ms. Schaub say, all right, I'm busy now, and if you wait 15 minutes, I will then attend to. I did not hear that she was going to print anything. She was going to deal with what I wanted. I had expected to start seeing immediately or get in an envelope the material I had requested 8 days earlier, and which 10 days earlier, approximately, in which she said had been supplied electronically on the 8th of March, 5 days before I was even there. That's what I expected, and I have done it over and over again. I've inspected places and the executive offices. I've looked at monitors. I've looked at material that was handed to me as the agenda was. It was very routine, but this was refused this time.
So it was routine for them to give you the materials in hard copy when you had requested them?
Yes,
okay,
absolutely. And I have that in the immediate disclosure requests, specifically saying I'd like the material via email and in person at your office. And that was standard boilerplate. I've drawn a line through one of the attachments that shows an extra email, but it's from February, a month earlier, and it has the same boilerplate that I've provided about how I would like to receive the responses. So it was pretty routine. And all of a sudden now it wasn't. And she insisted that I had to make an appointment before she would even print out anything.
So when she asked if you could wait 15 minutes, you didn't think she was going to give you the materials at the end of that 15 minutes?
No, she said she was busy and she had something else to deal with, and that I should wait until presumably she was done with that business. And then presumably she might print stuff out, but she might give me another load of objections and whatnot. And I've experienced these kinds of objections before, and I've had to politely say, look, this is how I requested it, and this is how I would appreciate getting it.
Okay, thank you. I think those were all my questions.
Can I respond to that?
Sure. I mean,
if Member Stein wants you to.
It's just not that wasn't my experience there. I told him I was doing, that just wasn't the experience. I feel like it's a very big mischaracterization. He did receive the documents. We gave it to him. I told him he could not inspect them on my computer. That was the only thing I said. I said if he could come back in 15 minutes, because we don't print everything out the day that he asks for it. We deliver it through next request and we deliver it through email. And if he wants to come to the office and get them, then I'll print them out. But we are the library, and we like to save paper, and we're trying to be environmentally conscious. So I'm not printing out things unless I know for sure someone needs them or is going to come pick them up. So that was the discussion that I had with Mr. Warfield. But
Did you see in his original request that he actually asked for the documents both by
Yes.
email, specifically not through Next Request, and also specifically in hard copy?
he's to inspect in our offices, so he doesn't always come and get them when he asks for the hard copy. So since this interaction, what I've done is I print them out and I put them at the information desk at the main library. And if he picks them up, he picks them up. But at that time, the way that I interacted with Mr. Warfield that I remember is he doesn't come to the office and they're there in the office for him to pick up. We send them to him by email and through Next Request. And if he requires them in hard copy to inspect, I then print them out for him. And
Okay.
he came to the office and he said, "Do you have something for me?" I said, "What are you, I don't know what you're talking about." When he clarified what he wanted, I said, "If you can either wait or come back in 15 minutes, I'll print them out for you."
You specifically said you would print them out.
Yes, I said, "If you can come back in 15 minutes or wait 15 minutes, I'll print them out for you." I mean, I think it was a lot of printing.
Mm-hmm. Can I just ask again to Mr. Warfield, do you recall being her saying specifically that she would print them out?
I'm sorry, what about printing out?
The respondent says that she told you that if you could wait 15 minutes, she would print them out for you. Do you recall that being conveyed?
Remember, there was a request to wait for 15 minutes while she did something entirely different. And as a matter of fact, I did not have time at that moment, but I fully expected, as with the agenda that I picked up Friday at about 4:45, 20 to 5, that I would be getting, as Ms. Singleton gave me, a brown envelope with the agenda that I
Okay, I want to be really specific. If you could just answer this yes or no. On Monday, when you came back, do you recall her saying that she would print out the documents for you, yes or no?
No, I recall her saying she would deal with this, and I didn't really know, first of all, how long the 15 minutes might actually be, given the resistance that I got when I first walked in, and the many options that she was proposing for me to do as reasons why she shouldn't have to provide me anything there. I wasn't certainly sure that there would be anything printed when the 15 minutes was up.
Okay, thank you.
We have always
But I
printed
was
for
clear
him,
that she
and
said
when
she
he's
would
asked
not
for them,
print.
we
I
have
bet
given them
it
to
was
him. So I
clear.
think, again, this is a mischaracterization.
I think we
It's
need
just not factually true.
let's just get some order here. I don't know if there's a question pending, so I don't want to have the parties arguing. But Member Stein, any more questions for the parties here?
No.
Okay, thank you. Member Wolf, I don't have any questions.
No questions. Member Stein covered
Okay.
all my concerns.
Okay, yeah, thank you. So at this point, we can determine the basics and figure out, we send this to the full task force to have everyone hear it. Obviously, we can't make any decisions here. The rules don't allow us to do that. Members, any thoughts?
So I'm personally sort of torn on this because I feel like there's a serious dispute of facts about what actually happened. The stories are very, very different, and depending on what happened, I might handle this differently, but I feel like I don't know what happened. I'm not even sure that if we discuss it further in the task force meeting, that I'll have any idea, exactly what happened. So given that that's the case, I mean, if I felt like I knew, I mean, to me, if the library had said, and there was agreement that they had said, just wait 15 minutes, come back, I'll print it out for you, then I would argue that, well, 15 minutes is not an unreasonable delay. And, in that case, I don't think I would find a violation. I would recommend consent calendar and no violation, but I feel like I don't know for sure what was said. So guess I don't feel like there's much choice but to send it to the full task force from my point of view, but I don't know that there will be much more clarity there either.
Any thoughts, Mr. Wolf, Member Wolf?
Yeah, I agree with Member Stein in part. I would just forward it to the task force with no recommendation. The action that was intended by the complainant as the requester is, has validity. What transpired, I'm not completely clear on that at this point. But nonetheless, whether it's within our jurisdiction or not, yes, it's within our jurisdiction. Are the records public? Yes, the records are public. So I would leave it at that.
I think we're all on the same page here. Who wants to be the maker of the motion?
I'll move it.
Okay.
Move to that we find that it's the complaint is within jurisdiction of the Sunshine Ordinance, and that the records are public, and that the complaint complies with. Well, I don't need to say that. It's within jurisdiction. So, yeah, just those 2 points. And to forward it to the task force for a hearing schedule.
I can second that. This is Member Stein.
Okay, public comment.
Yes, if there's any members of the public who'd like to make public comment, you can approach the podium. If you're online with us, you can raise your hand by either pressing *3 if you're on the phone, or otherwise raising your hand. I'm seeing no indication for public comment on this matter.
All right, vote.
Member Wolf.
Aye.
Member Wolf, aye. Member Stein.
Aye.
Member Stein, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. 3 in favor.
All right. Thank you to the parties. Let's move to the next item.
Item number 7, file number 23050, complaint filed by Michael Petrellis against Supervisor Aaron Peskin, President of the Board of Supervisors, for allegedly violating Administrative Code Section 67.29-5 by failing to respond to a request for Proposition G calendar in a timely and/or complete manner. This is the first time this matter has been heard.
Okay. I believe we heard that Mr. Petrellis is present by remotely. And is there anyone here on behalf of Supervisor Aaron Peskin? We do have someone in the room. So we will start by hearing from the petitioner for up to 3 minutes. And then could we get your name, the respondent?
Yes, this is Calvin Yan, Legislative Aide to Supervisor Aaron Peskin.
Okay.
Calvin Yan. Yep.
Okay, thank you. All right, when Cheryl's ready, we can hear from Mr. Petrellis.
Mr. Petrellis, are you with us?
Yes, I am.
Okay. You may begin.
I've just started my stopwatch. Hi, this is Michael Petrellis, and I'm looking at the attachment here that's 34 pages, and I wish to call your attention to Peskin's response starting on page 16. First of all, I believe the overall attitude of Aaron Peskin here regarding his calendar is that he believes less is more. Less information about who the attendees were, less information about how long he may have been at the meeting. And I find that unacceptable. I think in the matter of the Prop G calendars, that more information is what's necessary regarding topics discussed and attendees. Next point. Aaron Peskin has been at City Hall since 2001. He's been there for decades. And if he is really this unfamiliar with how to keep a comprehensive Prop G calendar, it shows he's really not respecting our local sunshine laws. Now, on what is page 16, it's numbered page 1, he talks about a revised record regarding a meeting about the Castro Theater. And all of those names that he finally provided to me could have and should have been included in his original response. Then on page 17, he says under clarification, given my short attendance, approximately 10 minutes, I don't think it matters, and I also do not believe that he really was at that meeting for only 10 minutes, given his extensive comments about the Castro Theater. He should have been providing this information without a further request. On page 17, under clarification, he says, given our office's numerous past exchanges, he says it's the understanding that a legend of abbreviated staff names had been provided to me. Even if they had been provided, which they hadn't previously, he has a duty to clearly spell out every attendee's name and not be so nitpicky about he can't say Aaron Peskin and instead has to say the initials AP, or he can't say Sonny Agulo, he has to say SA. Really, in every calendar entry, state all the full names. Thank you.
Thank you. Okay, now we can hear from the respondent. When Cheryl's ready.
Are you ready to begin, Mr. Yan?
Yes.
Okay. Go ahead, sir.
All right. Thank you, commissioners. My name is Calvin Yan, representing Supervisor Aaron Peskin on this file. And I think the complaint right now is referring to a request received and sent from Mr. Petrellis on April 18th. Our office actually responded quite quickly on April 20th, within 2 days, as soon as we can. I know that Mr. Petrellis has sent a follow-up email clarifying some of the issues or questions that he has about the calendar invite that we have sent him on April 20th and again on 26th. Unfortunately, our office did not see those clarification emails until we actually received an official complaint on April 27th. And at that point, we were trying to clarify some of the question. And we just want to say that this is not the first time Mr. Petrellis has asked us to produce a calendar. He has been working closely with our staff who has been, the person who's been creating these calendars multiple times, Sarah Souza. So we always are open to answer any question that he has. On the 3 things that he has asked for about the attendees, I don't know how we can debate whether Supervisor Peskin has indeed only been the meeting regarding another plan for 10 minutes. He was only there 10 minutes, so we were able only to provide whatever he was there for. On the second point, meeting with a group of stakeholders, there was more than 10 members, so we did not initially include all the members because there was no recollection of every single member that was there. And then the thirdly, staff initial, same reason that we provided in the document, CAAP, these abbreviation has been used many times in many record. I don't understand why why he has to ask for these again, but if he asks again, we're happy to provide it in the future. So I think overall, our office thought that we provide information as soon as we can. And we're always happy to work with him on any clarification that he has. Thank you.
Thank you. Members, any questions?
Member Stein, I do have a question for Mr. Petrellis. You gave examples in your complaint of incomplete calendar entries. Were these examples a complete list of information you believed was incomplete, or just representative examples?
Representative examples. There are other instances where there is incomplete information about attendees, their full names, topics discussed, and whether attendees represented a corporation or so.
Okay, thank you. That was my only question.
All right. I have no questions for the parties here. It's very straightforward. Member Wolf, and we have seen a lot of these calendar cases, so we
No questions.
think it's a pretty clear area. Okay, no questions from Member Wolf. Anyone want to make a motion on this? I would just suggest that just based on what our experience is with these, maybe one thing that would be on the table possibly is whether it goes on the consent calendar as a violation case. But I'll leave that to the other members. Otherwise, I'm sure that we do send this to the task force to resolve. I'll move that we find that, yes, these are public records. We do have jurisdiction, the task force has jurisdiction, and that this should be forwarded to the task force to have a hearing on potential violations.
I'll second that.
Okay, let's see if there's any public commenters.
Yes, if any members of the public would like to make public comment, you can approach the podium at this time. If you're remote, you can raise your hand by pressing *3 if you're on the telephone, or otherwise using the application to raise your hand. I'm seeing no indications of public comment at this time.
Okay, public comment is closed. Let's vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Member Wolf?
Aye.
Member Wolf, aye. 3 in favor.
Okay. All right, we have one more case matter. Again with Mr. Petros. Is there a person here on behalf of Dean Preston? Yes, we do have a representative here. Go ahead and call the case, Cheryl, and then we'll ask for identification.
Item number 8, file number 23051, complaint filed by Michael Petrellis against Supervisor Dean Preston, Board of Supervisors, for allegedly violating Administrative Code Section 67.29-5 by failing to respond to a request for Proposition G calendar in a timely and/or complete manner.
Okay, could we get the name of the person who is here on behalf of Ms. Dean Preston's office?
Jennifer Bolin, Bolen.
Thank you. All right, so first we'll hear from Mr. Petrellis and then the respondent's office.
Ms. Petrellis, are you ready to begin?
Yes, I am. I think this is relatively straightforward. I was not provided the Prop G calendar within 3 business days. At I think the last complaint committee, it was affirmed that the Prop G law does require providing the calendars within 3 days after a meeting has happened if a public request is made. So my understanding, and you can correct me if I'm wrong, is that I should have been given the records requested because it was well within that 3-day period, and Supervisor Dean Preston's office, instead of giving me the calendar within those 3 business days, it took a 14-day extension. They granted themselves a 2-week extension, and I was not at all pleased with that. And I will end by saying, eventually they did produce acceptable calendars with, it was clearly explained where meetings took place, who was in attendance, topics discussed, length of meetings, etc. So the issue was not what was in the calendars, it was the length it took for them to be released. Thank you.
All right, great, thank you. And when Cheryl's ready, we can hear from Ms. Bolin.
Are you ready, Jennifer? Okay.
Hi, everyone. Everything Mr. Petrella says is correct. And I just want to share that after the last task force meeting where I had a similar issue with Mr. Petrella, or Mr. Petrella had a similar issue with our office, on the advice of the discussion after task force, we changed the processes in our office and also reviewed things with staff and supervisor and ourselves to make sure that we change our process on the calendar to make sure that we're able to produce things within the 3-day time period, so we don't waste the task force time anymore or the public's time anymore. And that's all I have to say. I just didn't want to not show up because that'd be rude. Thank you.
Thank you.
Thank you. Any questions for the members?
I have a question for the respondent, Ms. Bolin. Are you aware that you can just agree that there's been a violation if no? Okay.
No, sorry about that. I'm not used to this.
Okay.
So yeah.
Yeah, okay, because I think there's a form that we send to you initially when there is a complaint, which asks if you want to contest that there's a violation or not. And I think in the case of your office, you all have realized that there was a problem with the Prop G calendar. Hopefully it is fixed. But if you know that there was a violation, you can just say that you don't contest it. And then that also helps streamline the process if there's just been a clear violation.
Thank you. Hopefully I'll never have to use that again though. Yeah.
And just tell her to refer to the affirmation letter as well, because it's pretty clear in there as well.
So there's an affirmation letter, I guess, that you get.
Yeah.
And it's clear in there how that part of the process works. That's all.
Is there anything I should be doing now on that for you, or just for if there is a next time to keep in mind?
I think that
Please. Oh, go ahead.
Yeah, we're probably going to, if the members agree, we'll probably send this on to the task force as a consent calendar matter, because it appears that there's no contest being made here, and you're not contesting that there was a violation. And that's all we would need. I don't think there's any need to have the document written, because we can't make a final decision of any kind here anyway. It would have to be rubber stamped at the task force consent hearing.
I just want to point out, consent calendar, when it's heard at the task force level, it's not required that the parties be present.
Okay.
So if you can't make it.
Okay. Thank you.
Yeah.
Yeah. Members, who would like to make the motion to send this on to the consent calendar?
I can do it if you don't want to, but so I will just say these are public records that are under our jurisdiction, and that we forward it to the consent calendar for a violation of 67.29-5 for not responding in a timely manner to a request for a Prop G calendar.
Second.
Okay, any public comment?
Yes, if there's anybody who would like to make public comment at this time, you can approach the podium or otherwise use the application to raise your hand.
I believe we do have someone in the room here, Victor. If there's nobody online, let's go ahead with our public commenter here.
Yes, there's nobody online for public comment. We can move to the in-person public comment.
Okay, when Cheryl is ready.
Ready, Mr. Warfield?
Yes. Peter Warfield, Executive Director, Library Users Association, Library Users, 2004 at yahoo.com and P.O. Box 170544, San Francisco, California, 94117-0544. We're not a party to this. We're not familiar with this except from what we've seen and heard in the room. But what I would like to say is that it strikes me as, from the perspective of somebody who's followed somewhat what goes on at Sunshine, we've had several years of very numerous complaints. You might call it an audit of city departments with respect to violations of Prop G. Over and over, there were dozens upon dozens upon dozens of violations. I'm not sure how many of those, if any, were directed towards supervisors. But I do think that the repetitive nature of these violations suggests a number of things that I think the Sunshine Task Force should be interested in looking into. I have a great deal of respect and appreciation for the supervisors, and in particular, Dean Preston, and I appreciate the fessing up, if you like, to making an error. But I do think that there's potentially something that the Sunshine Task Force ought to do under its, I believe it's Article 4, its duties to advise and report and even suggest changes to the law as they see fit. And when there is over and over and over and over again, dozens upon dozens of violations, it seems to me it would be very valuable for the Sunshine Task Force, including yourselves, especially since you have folks here, to find out what's the problem. Is it a lack of education? Have folks not gone to the city attorney's annual education session on Sunshine, on the Sunshine Ordinance, and what department heads, for example, and others are required to do under that law? Maybe they're not mentioning it. I don't know. But I think that when there's constant and consistent and frequent violations over and over, despite your having ruled on what the law requires, I think it would be valuable to take the opportunity to find out and do a little research, especially while you have them here, about what's going on and why. Thank you.
Thank you. Okay, let's vote on that.
I did not hear who was seconding your motion.
Member Wolf.
Member Wolf, great, thank you. Member Stein?
Aye.
Member Stein, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair Schmidt?
Aye.
Chair Schmidt, 3 in favor.
All right, next item.
Item number 9, announcements, comments, questions, and future agenda items by members of the Complaint Committee.
I don't have anything on this item. Any other members have anything you want to bring up?
Nope.
Okay. So, nothing on that. I guess we probably should move on and adjourn. Number 10.
Item number 10?
Yeah.
Item number 10, adjournment. I have 7:14.
Move to adjourn.
Second. You are done with that one.